Well, when COVID hit, Washington State issued an emergency rule to keep juvenile detentions numbers low by only issuing arrest warrants for violating court orders or failing to appear in court for juveniles who posed a serious threat to public safety.
Then they made it permanent, despite protests from parents, juvenile court administrators, and treatment providers. KVUE's Emily Goodell reports opponents are now fighting that rule and asking that the state Supreme Court to take it back because it's stopping kids from getting help.
When Karen Mobley's granddaughter violated court orders for her probation for felony assault, failed to appear in court, and ran away from home, Mobley couldn't get them to issue an arrest warrant so police could bring her granddaughter home.
I cried at night, wondering where she was, wondering if she was hurt, raped, or dead.
She eventually came home, traumatized, pregnant, and with a long road to recovery.
When I needed the court's help the most, I couldn't get the help I needed. I wish we could have intervened sooner.
Opponents of Juvenile Court Rule 7.16 say instead of protecting kids, the rule is actually hurting them because it focuses on whether juveniles are a threat to public safety while ignoring any safety risk the juvenile might pose to themselves, especially when it comes to drugs.
While our state experiences a staggering fentanyl crisis among our teens, the people who used to be able to help now watch unable.
As treatment providers, we need to have the ability to use the existence of legal consequences as the alternative if the youth chooses not to follow the court orders.
Because right now they can walk away, violate court orders, and skip their court dates without fear of getting arrested. And for some, that means dire consequences.
We are seeing kids pass away before they get the chance to grow up.
In Okanagan County, a 17-year-old girl with mental health and substance abuse issues ran away from her court-ordered treatment. No arrest warrant was issued despite multiple violations after that. By the time the court issued an arrest warrant, it was too late. The 17-year-old had fled to the next state over and shot herself.
One of the most significant difficulties with this rule is our inability to help families in crisis. Looking into the eyes of a parent or a grandparent who's standing in front of me in court, begging me to help them with their child who is in danger and in crisis is agonizing. And when I can't help them, it's even more agonizing.
The Superior Court Judges Association and the Washington Association of Juvenile Court Administrators is asking the state Supreme Court to rescind 7.16, or if not, at least amend it to issue warrants when a juvenile poses a threat to public or individual safety.
People of good faith can disagree about whether this rule should be rescinded, retained, or modified. That I believe all of us believe that there is hope for rehabilitation for juvenile, and the struggle is finding the right way to effect that promise of hope.
Emily Goodell, KVUE Local News.
The Supreme Court is accepting public comment on this issue now through April 2023 as they decide how to move forward.